Before we begin, a quick and important disclaimer. The content provided in this video is strictly for educational and entertainment purposes only. I am not a licensed attorney, a certified financial planner, a tax professional, or a legal advisor. Divorce law, asset division, child custody metrics, and family court proceedings vary wildly depending on your specific jurisdiction, and the legal landscape is incredibly complex, especially in high net worth or heavily regulated coastal regions of the United States. The information discussed here regarding potential outcomes, historical trends, and case studies should not be construed as professional legal or financial advice under any circumstances. The breakdown of a marriage involves deeply personal, highly nuanced, and legally binding variables that require specialized, localized counsel. You must conduct your own extensive due diligence and consult with a qualified, board-certified family law attorney in your specific state and county before making any decisions, signing any legally binding documents, moving out of your marital home, or altering your financial structure in any way. Do not use this video or any online content as a substitute for legitimate, retained legal representation. Picture a man in his mid-40s living in the San Francisco Bay Area. Let us look at a composite case study based on historical trends in family law, and we will call this individual David. David spent 15 years building a specialized tech consultancy from the ground up, pouring 80-hour weeks into his business, while living in one of the most brutally expensive real estate markets on the planet. He and his wife purchased a modest 3-bedroom home in Marin County for $1.5 million early in their marriage, which over a decade of aggressive coastal market appreciation, ballooned to a valuation of nearly $3.8 million. David felt remarkably secure. He genuinely believed his immense personal sacrifices and heavy workload had insulated his family against economic instability. Then, on a random Tuesday, he was served with divorce papers. Within 18 months, David was living in a severely downgraded, rented studio apartment in Oakland. He was forced to liquidate a massive portion of his business equity at a steep, unfavorable discount simply to satisfy a community property buyout order from the court. The Marin County house was sold because neither party could afford to buy the other out, and the proceeds were instantly decimated by capital gains taxes and aggressive attorney fees that collectively exceeded $250,000. On top of that total asset depletion, he was ordered to pay a staggering monthly spousal support figure based on a forensic accounting of his absolute highest earning year, completely ignoring the current downward trending reality of his business sector. David did not do anything maliciously wrong. He did not hide money offshore, nor was he the victim of some grand vindictive conspiracy. He was simply a man who entered the family court system in a major United States coastal city, completely blind to the geographical realities of his situation. You are a man going through, or even quietly contemplating, a divorce in a major U.S. coastal metropolis like Los Angeles, New York City, San Francisco, Seattle, Boston, or Miami. You are facing a fundamentally different legal and financial battlefield than someone dissolving a marriage in the Midwest or the rural South. The sheer, overwhelming cost of living, the aggressive state taxation structures, and the hyperinflated real estate markets in these metropolitan hubs act as a high-stakes pressure cooker on the dissolution of a marriage. The statistics and historical trends are absolutely brutal for the unprepared. Historical data indicates that men in these specific high-cost-of-living areas often experience a severe and immediate decline in their standard of living post-divorce, a drop that is statistically much sharper and more prolonged than national baseline averages. We are talking about geographical regions where a low six-figure salary barely covers a standard middle-class lifestyle. Therefore, the mathematics of splitting one consolidated household income into two entirely separate, highly taxed households often leads to catastrophic financial strain and sudden insolvency. Furthermore, the coastal states often feature incredibly progressive, deeply entrenched, and highly complex spousal support and property division frameworks. In California, for example, a marriage lasting over 10 years is legally designated as a marriage of long duration. This seemingly simple classification means the family court retains jurisdiction over spousal support indefinitely, meaning the higher-earning spouse could potentially be on the hook for alimony until retirement, or even death, depending on the circumstances. In New York, the doctrine of equitable distribution does not automatically mean a clean mathematical 50-50 split of assets. Instead, it leaves immense, life-altering discretionary power in the hands of a judge who will heavily scrutinize your current earning capacity, your future financial trajectory, your health, and your specific financial contributions to the marriage. In Seattle or Silicon Valley, The courts have become incredibly aggressive in how they value unvested restricted stock units, stock options, and intellectual property, often treating future, unrealized gains as current marital assets ready for immediate division. The men who lose everything in these coastal cities generally do not lose because the system is inherently, legally rigged against their gender. They lose because they operate under outdated, emotional assumptions and fundamentally fail to understand the specific macroeconomic and legal mechanics of the zip code in which they are getting divorced. They walk into a high-stakes legal negotiation treating it like a simple emotional breakup, rather than the complex, adversarial dismantling of a multi-million-dollar corporate partnership, which is exactly how the state and the courts view your marriage contract. This video is your comprehensive, unsugar-coated masterclass on navigating the treacherous, highly regulated waters of divorce as a man in a U.S. coastal city. By the end of this deep dive, you will understand exactly what problem this solves for you today: the problem of catastrophic legal and financial ignorance. We are going to meticulously dismantle the exact geographical and legal traps that routinely destroy men's finances in places like Manhattan, Seattle, and Silicon Valley. You are going to learn the critical foundational differences between community property states like California or Washington and equitable distribution states like New York or Massachusetts, and how those frameworks specifically interact with highly appreciated assets like coastal real estate, specialized business valuations, and tech equity. We will thoroughly explore historical case studies of men who successfully navigated high-conflict divorces by utilizing forensic accountants to accurately trace separate property, and we will contrast those victories with the cautionary tales of men who were financially eviscerated because they tried to hide assets, failed to understand tax implications, or attempted to negotiate without leverage. We will give you the precise analytical tools to understand how coastal courts calculate temporary and permanent alimony in environments where rent alone is $4,000 a month, and how you can strategically position your business structure, your reported income, and your current housing situation to mitigate long-term damage. You will discover the common psychological warfare and legal posturing often deployed in high-stakes coastal divorces, from the strategic timing of filing to maximize bonus capture, to the aggressive freezing of joint brokerage accounts before the official date of separation. More importantly, we will outline the potential outcomes of engaging in aggressive, scorched earth litigation versus pursuing collaborative divorce, private arbitration, or structured mediation, showing you exactly when it makes mathematical sense to fight in court and when it is imperative to settle. This is not about seeking petty revenge or trying to cheat your spouse out of what is legally and morally fair. This is about absolute, calculated self-preservation. It is about protecting your ongoing relationship with your children from parental alienation, shielding the complex assets you bled to acquire over decades, and ensuring that you do not spend the next 20 years of your prime earning life financially indentured to a past relationship simply because you lived in a state with punishing family law statutes. If you live on the coast and your marriage is ending, the margin for error is exactly zero, and your preparation must begin immediately. The very moment you realize the marriage is irreparably broken, an invisible starting gun fires. The vast majority of men in coastal cities fail to hear this shot. They assume the formal legal process begins when someone is physically handed a petition for dissolution of marriage by a process server. This is a catastrophic misconception based on outdated television tropes. In the high-stakes reality of 2026 family law in places like Los Angeles, San Francisco, or New York, the legal maneuvering begins months, sometimes years, before any official documents are filed with the county clerk. Historical trends in family court litigations overwhelmingly demonstrate that the spouse who controls the early flow of financial information and establishes the initial narrative dictates the trajectory of the entire settlement. You must shift your mindset from emotional triage to forensic defense. Imagine if you were dissolving a multimillion-dollar corporate merger. You would not simply walk away from the negotiation table, leave the corporate headquarters to your estranged partner, and hope they calculate your severance package fairly. Yet, this is precisely what thousands of men do every single month when they face a divorce. They prioritize short-term emotional peace over long-term structural security, a decision that coastal family courts frequently interpret as a willingness to accept an inferior financial outcome. Let us examine a highly relevant scenario based on common potential outcomes in the current economic landscape. Consider a man named Michael living in Seattle in the year 2026. Michael is a senior software engineer whose compensation package is heavily weighted with restricted stock units and performance-based equity. He and his spouse have been experiencing severe, unresolvable marital issues for over a year. In a misguided attempt to de-escalate the daily tension in their household, Michael voluntarily packs a bag and moves into a moderately priced short-term rental in Bellevue, assuming they are just taking a physical break to figure things out. He continues to pay the massive mortgage on their primary residence, covers all the utility bills, and pays for his new rental out of his base salary. Fast forward 6 months, and his spouse formally files for divorce. By voluntarily leaving the marital home, Michael has inadvertently triggered a cascade of disastrous legal precedents. In family law terminology, he has established a new status quo. By demonstrating to the court that he is financially capable of sustaining both the overwhelming overhead of the coastal marital home and his own separate living expenses, he has essentially handed his spouse a verified blueprint for maximum temporary spousal support. The court looks at the historical trends of his financial output over the past 6 months and determines that Michael can afford this dual household burden permanently. Furthermore, by leaving the physical premises, Michael has relinquished his daily access to critical physical documents, home safes, and mail, putting himself at a massive disadvantage regarding information asymmetry. The concept of the date of separation is another geographical and legal trap that completely blindsides men on the coasts. In community property states like California and Washington, the specific date a couple is deemed legally separated is the exact hard line drawn in the sand. Every single dollar earned, every stock option vested, and every asset acquired before that specific date is generally considered joint marital property subject to division. Everything earned after that date is theoretically your sole and separate property. The financial difference between a separation date of January 1st versus November 1st can literally amount to hundreds of thousands of dollars, especially if you are anticipating an annual corporate bonus, a massive commission payout, or a cliff vesting schedule for your tech equity. If you do not actively, legally, and definitively document your separation date, your spouse can and often will argue for a later date to capture a significant portion of your upcoming financial windfalls. Coastal courts often utilize complex time rules, such as the Hug formula or the Nelson formula, to divide unvested stock options based on the exact timeline of your marital status. You cannot rely on a verbal agreement or a text message saying you want a divorce. The coastal courts require demonstrable, objective proof of a complete and final break in the marital conduct, which usually involves a clear communication of the intent to end the marriage accompanied by outward actions consistent with that specific intent. This brings us to the absolute necessity of preemptive, comprehensive document collection. The discovery phase of a coastal divorce is notoriously brutal, prohibitively expensive, and highly invasive. Attorneys easily bill at rates exceeding $600 to $900 an hour simply to subpoena bank records, trace missing wire transfers, and unearth hidden credit card debts. If you wait until the formal discovery period mandated by the court to understand your own financial footprint, you are already hemorrhaging money. Before you ever utter the word divorce to your spouse, you must secure a pristine, undeniable digital archive of your entire financial life. This means downloading at least 3 to 5 years of complete joint tax returns, W-2 forms 1099s, K-1 schedules for any business partnerships, and every single bank and brokerage statement tied to your name or your joint accounts. In the year 2026, where digital assets and decentralized finance are ubiquitous, you must document all cryptocurrency wallet addresses, private equity buy-in agreements, and peer-to-peer lending histories before access can be restricted. Historical case studies frequently reveal that spouses anticipating a divorce will methodically begin siphoning funds from joint checking accounts into undisclosed separate accounts, quietly racking up marital debt on shared credit cards to artificially deflate the community estate, or abruptly changing the passwords to shared financial portals. You must become a ghost in your own financial ecosystem, quietly and legally auditing every single inflow and outflow. You need to know the exact payoff amount of your coastal mortgage, the current cash surrender value of your whole life insurance policies, the specific cost basis of your real estate investments, and the precise vesting schedule of your retirement accounts. This level of granular, hyper-vigilant preparation is not paranoid behavior. It is the absolute baseline minimum requirement for survival in jurisdictions that often treat high-earning men as infinite resources for wealth redistribution. The men who survive the coastal family court system intact are the ones who treat the pre-filing phase as a covert intelligence gathering operation. They understand that leverage is not benevolently granted by the judge on the day of the trial. Leverage is meticulously built in the shadows before the first legal motion is ever drafted. But all of this careful financial cataloging, all of the strategic preservation of the status quo, And all of the meticulous documentation of the separation date can be instantly vaporized if you fall into the most dangerous, emotionally explosive trap of the entire modern divorce process. What happens when your spouse realizes you are actively preparing your legal defenses, and they decide to bypass the slow financial negotiation entirely by launching a sudden preemptive strike designed to legally, physically, and instantly force you out of your home without a single word of warning? What do you do when the ultimate, most destructive weapon of the modern family court is pointed directly at your reputation and your freedom? That destructive weapon, frequently deployed in the highest-stakes coastal divorces, is the ex parte temporary restraining order. In family law circles, the strategic misuse of protective orders to gain immediate, overwhelming leverage is sometimes referred to informally as a silver bullet tactic. To understand the sheer gravity of this potential outcome, you must first understand the legal mechanics of an ex parte proceeding. Ex parte is a Latin legal term meaning from one party. It means that your spouse, accompanied by their legal counsel, can walk into a family courthouse, present a narrative of fear or alleged threat to a judge, and request immediate protective action without you, your attorney, or anyone representing your defense being present in the room. The court, prioritizing the immediate physical safety of the petitioner over your right to due process in that specific moment, will often grant a temporary order based entirely on a one-sided, unverified declaration. The standard of proof required to secure this temporary, life-altering mandate is astonishingly low. It does not require a police report, it does not require medical records, and it does not require corroborating witnesses. A sworn statement claiming a subjective fear of imminent harm or emotional distress is frequently enough for a judge to sign an order that instantly evicts you from your own property. Let us examine a case study representative of historical trends in the year 2026, looking at a man named Christopher, a commercial architect living in Boston. Christopher and his wife have been trapped in a deteriorating, high-conflict marriage. They live in a tightly contested, $2.5 million brownstone. Neither party wants to voluntarily leave, because renting a comparable secondary residence in the Boston market would instantly consume Christopher's entire monthly take-home pay. One evening, an argument regarding credit card debt escalates. Voices are raised. Christopher, frustrated, slams a door and loudly tells his wife he cannot tolerate the financial mismanagement anymore. He goes to sleep in the guest room. The next morning, he commutes to his architectural firm. At 2 p.m, 2 armed police officers arrive at his reception desk. He is publicly served with a temporary restraining order. The immediate, cascading consequences of this single legal maneuver are absolute and catastrophic. Under the strict parameters of the order, Christopher is legally barred from returning to his home, even to retrieve his laptop, his business documents, or a change of clothes, unless escorted by law enforcement. He is prohibited from contacting his wife through any medium, meaning all direct negotiation regarding their assets is immediately frozen. Most devastatingly, the order includes temporary, exclusive physical custody of their 2 children to his wife, granting Christopher zero visitation rights until a formal evidentiary hearing can be scheduled, which in the heavily backlogged coastal court systems might be 3 to 4 weeks away. In a matter of minutes, based on a single slam door and a highly curated, one-sided legal declaration, Christopher is homeless, entirely separated from his children, and fundamentally disadvantaged in the impending divorce litigation. This specific geographical and financial pressure cooker is why historical case studies show a distinct correlation between high cost of living real estate markets and the sudden filing of domestic violence or protective orders at the inception of a divorce. In a market where neither party can comfortably afford to move out, the ex parte order becomes a state-sponsored eviction notice. By the time Christopher finally gets his day in court to present his defense and prove the allegations were an exaggeration designed for strategic leverage, the damage is already deeply institutionalized. His wife has established a solid 3-week precedent of being the sole primary custodial parent, a status quo that family court judges are notoriously hesitant to disrupt. Christopher has been forced to sign a 1-year, hyperinflated lease for a downtown apartment just to have a place to sleep, destroying the marital cash reserves. Furthermore, the sheer financial burden of defending against a restraining order is immense. Christopher cannot rely on a standard family lawyer for an evidentiary hearing that carries quasi-criminal implications. He must retain a specialized litigation attorney, requiring an immediate, separate retainer often exceeding $25,000. To navigate this incredibly hostile potential outcome, legal professionals specializing in high net worth divorces advise a strict, uncompromising adherence to proactive de-escalation. If you reside in a coastal jurisdiction and sense your marriage heading toward dissolution, you must immediately assume that every single interaction, every text message, every email, and every verbal disagreement is being actively curated for a future legal exhibit. Historical trends dictate that you must remove the very oxygen that fuels an ex parte declaration. This means adopting the gray rock method of communication. You do not raise your voice. You do not block doorways. You do not engage in circular, late-night arguments about past grievances. If a conversation becomes heated, you calmly state that you are stepping away from the discussion, and you immediately physically leave the environment. You go to a coffee shop, you go to a public park, or you go to your office. You remove your physical presence so completely that no credible allegation of a threat can be constructed. Furthermore, you must thoroughly understand the electronic surveillance and recording laws of your specific state. In one-party consent states like New York, men facing high-conflict divorces frequently protect themselves by utilizing voice-activated recorders during any face-to-face interaction with their spouse, ensuring an objective, unalterable audio record of events. However, in aggressive two-party consent states like California, Washington, or Massachusetts, recording a conversation without the explicit permission of your spouse is a criminal offense that will be immediately used against you in court. Therefore, the strategic alternative is to insist that all substantive conversations regarding the relationship or finances occur exclusively in written format, or in highly public spaces where the presence of witnesses naturally regulates behavior. You are essentially transforming your own home into a highly monitored, strictly professional environment to protect your freedom and your future access to your children. You have navigated the physical threat. You have avoided the legal ambush of an ex parte eviction order by maintaining ironclad emotional control and understanding the specific, dangerous rules of engagement in your zip code. You are living separately, the dust of the initial filing has settled, and you are preparing to negotiate the division of your estate. But as you sit in your attorney's office reviewing the initial financial demands from opposing counsel, you notice a calculation that makes your blood run cold. They have submitted a demand for child and spousal support that completely ignores the actual salary you are currently earning. They are not basing your financial obligations on the money entering your bank account today. Instead, they are using a deeply complex, incredibly dangerous financial maneuver to tax you on a theoretical reality. What happens when a coastal family court actively decides that you are intentionally underemployed? How do you defend yourself and your financial future when a judge legally mandates that you should be earning twice as much as you actually are, and mathematically anchors your alimony to a phantom income that does not exist? The legal concept you are facing in this terrifying scenario is known as imputed income, and it is arguably one of the most dangerous and widely misunderstood financial weapons deployed in modern family law. Imputed income is a legal mechanism where a family court judge determines that you are voluntarily earning less money than you are reasonably capable of earning. Instead of calculating your spousal or child support obligations based on the actual verifiable dollars hitting your checking account every 2 weeks, the court legally constructs a phantom income. They tax you on your historical earning capacity. In the high-stakes, hyper-expensive jurisdictions of U.S. coastal cities, this judicial discretion can instantly transform a manageable divorce settlement into an inescapable debt trap. Historical trends in these metropolitan courts indicate a heavy bias toward maintaining the financial status quo of the dependent spouse, often at the direct expense of the primary earner, who may be experiencing a genuine, involuntary career downturn. Imagine if you are a man named Marcus living in Los Angeles in the year 2026. Marcus is a senior logistics director who spent the last decade earning a base salary of $350,000. However, the macroeconomic landscape of 2026 is volatile due to massive industry consolidation and the aggressive integration of artificial intelligence in supply chain management. Marcus's entire division is rendered obsolete. He is laid off. He receives a modest severance package, which is immediately categorized as marital property. Marcus spends 6 grueling months aggressively applying for roles, but the market has fundamentally shifted. The only comparable position he can secure in the Los Angeles area pays $175,000. Mathematically, his income has been slashed in half. In a logical, equitable system, his pending spousal support obligations would be proportionally reduced. But in the adversarial arena of a coastal divorce, opposing counsel files an aggressive motion claiming Marcus is intentionally underemployed. They argue that he purposefully took a lower-paying job to intentionally starve his estranged wife out of her rightful standard of living. Opposing counsel will present Marcus's previous 5 years of tax returns to the judge. They will highlight his elite educational background, his extensive management resume, and the fact that he resides in one of the largest economic hubs in the world. They will ask the court to legally impute his income back to $350,000. If the judge agrees, the potential outcomes are catastrophic. Marcus might be taking home roughly $9,000 a month after California state and federal taxes on his new salary, but his court-ordered support payments could be calculated at $8,000 a month based on the phantom income. This leaves Marcus with exactly $1,000 a month to pay for Los Angeles rent, utilities, food, and his own legal representation. It is a mathematical impossibility that forces men into rapid insolvency, liquidating their protected retirement accounts just to avoid being held in contempt of court for failing to pay support. To defend against the imputation of income, you cannot simply walk into a courtroom, shrug your shoulders, and hand the judge a corporate termination letter. You must treat your career trajectory and your job search as a forensic legal defense. When you suffer an involuntary reduction in income, the burden of proof immediately shifts entirely to you. You must empirically prove to the court that your reduction in salary is permanent, involuntary, and reflective of the current market reality, rather than a temporary strategic manipulation. This requires the immediate deployment of a highly specialized professional known as a vocational evaluator. A vocational evaluator is an objective, court-recognized labor market expert. You do not just hire them to say the job market is tough. You hire them to conduct a granular, data-driven analysis of your specific industry within your specific coastal zip code in the current year. If Marcus is proactive, his attorney will retain a vocational expert who will produce a comprehensive, 70-page report. This report will analyze Marcus's exact age, his specific technical skill sets, his physical health, and the precise macroeconomic data of the Los Angeles logistics sector in 2026. The expert will legally testify that the $350,000 roles Marcus previously held literally no longer exist in the local economy for his demographic. They will provide historical trends, Labor Department statistics, and interviews with corporate recruiters to establish that $175,000 is currently the absolute maximum ceiling of his earning capacity. This vocational report acts as an empirical shield against the emotional, accusatory arguments of opposing counsel. It replaces subjective legal posturing with undeniable, localized economic data. Furthermore, you must establish an ironclad, documented paper trail of your ongoing efforts to maximize your employment. Every single resume you submit, every rejection email you receive, every networking event you attend, and every interview you complete must be meticulously logged, time-stamped, and archived in a centralized spreadsheet. You are building an evidentiary timeline of good faith effort. If you are laid off from a lucrative tech job in Seattle, and you decide to take a year off to write a screenplay or launch a zero-revenue startup out of your garage, the family court will absolutely view that as voluntary underemployment. You have the fundamental right to change careers and pursue your passions, but the coastal family courts emphatically dictate that you do not have the right to finance your personal self-discovery by unilaterally deflating the standard of living of your dependent spouse and children. It is also vital to understand that the weapon of imputed income can be utilized defensively. This legal standard applies to both parties. Consider a scenario where your spouse holds a master's degree, but voluntarily chose not to work for the past 8 years of the marriage, and is now requesting maximum permanent alimony, claiming they have zero earning capacity. In many coastal jurisdictions such as California, you can request the court to issue what is known as a Gavran warning. This is a formal judicial notice requiring the supported spouse to make reasonable, good faith efforts to become self-supporting within a specific time frame. You can utilize your own vocational expert to evaluate your spouse's resume and prove to the court that they are perfectly capable of securing a $90,000 a year administrative role in their local metropolitan area. By successfully imputing a baseline income to a spouse who refuses to work, you effectively lower the mathematical gap between your two households, drastically reducing your long-term financial exposure. You have navigated the treacherous waters of temporary orders. You have stabilized your legal baseline. You have successfully defeated the phantom income trap by utilizing vocational data and treating your career shifts with forensic precision. You have established a realistic, court-approved understanding of what both parties should actually be earning. But as the financial discovery phase concludes, you are forced to look at the largest, most illiquid, and arguably the most emotionally toxic asset sitting squarely in the middle of the negotiation table. It is the coastal marital home. In previous decades, the resolution was simple. One person bought the other out, or they sold the property and split the equity. But in the volatile, hyper-inflated real estate environment of modern coastal cities, this house is a ticking time bomb. What happens when neither of you can afford to leave, neither of you can afford to stay, and the very mortgage rate attached to the property becomes a weaponized asset that traps you both in a state of absolute financial paralysis? This state of absolute financial paralysis is a uniquely modern phenomenon, deeply exacerbated by the macroeconomic climate of the year 2026. We are referring to the trap of the golden handcuffs, a scenario where a couple secured an incredibly low, sub 3% fixed-rate mortgage during the historical lows of the previous decade. In a major coastal city, that low interest rate is not just a financial convenience. It is the fundamental linchpin that makes living in a $2 or $3 million home mathematically possible for a dual-income family. When a divorce forces the dismantling of that household, the math violently shatters. In the past, the standard operating procedure was straightforward. One spouse would buy out the other by refinancing the property and pulling out cash to equalize the equity. But in the contemporary coastal real estate market, a buyout is frequently a mathematical impossibility. Imagine if you are a man named Robert, a commercial pilot living in San Diego, California. You and your wife purchased a property in La Jolla 8 years ago for $1.5 million. Today, conservative appraisals value that property at $3.2 million. Your remaining mortgage balance is roughly $800,000 at a highly favorable 2.75% interest rate. This means your marital estate holds roughly $2.4 million in trapped, illiquid equity. Under California community property law, if Robert wants to keep the house and maintain stability for his teenage children, he owes his estranged wife half of that equity, which equates to $1.2 million in cash. Because Robert does not have over $1 million sitting in a liquid checking account, his only mechanical option is a cash-out refinance at the current 2026 interest rates, which hover drastically higher than his original loan. When Robert runs the numbers, his relatively manageable monthly mortgage payment of roughly $5,000 explodes to an astronomical $16,000 a month. Even on a senior commercial pilot salary, allocating nearly $200,000 a year exclusively to housing overhead is financial suicide. When the buyout is proven impossible, couples are forced to pivot to the second option, which is selling the highly appreciated coastal asset and splitting the net proceeds. However, this triggers a secondary, equally devastating financial trap in the form of aggressive taxation. Many men fundamentally misunderstand how capital gains taxes interact with marital dissolution. The federal tax code allows a married couple filing jointly to exclude up to $500,000 of capital gains on the sale of a primary residence. But in Robert's case, the property has appreciated by $1.7 million. Even after applying the maximum married exclusion, there is still $1.2 million of highly taxable gain. In a jurisdiction like California, which taxes capital gains as ordinary income alongside heavy federal capital gains rates and net investment income surtaxes, the combined tax liability easily strips hundreds of thousands of dollars directly out of the family estate. The wealth they spent a decade meticulously building on paper evaporates in a matter of weeks at the closing table. Robert and his wife are left dividing a severely diminished pool of cash, forced to re-enter the unforgiving San Diego housing market as single buyers with purchasing power. To avoid the brutal reality of current interest rates and capital gains decimation, many high-earning coastal couples are attempting to implement experimental, trendy living arrangements that frequently act as hidden legal landmines. One of the most popular and dangerous trends in 2026 is birdnesting. In a birdnesting arrangement, the physical marital home remains completely intact, and the children live there full-time. The parents, instead of the children, rotate in and out of the house on a specific schedule, alternating their off days in a smaller, separate rented apartment that they share. On paper, it sounds like a deeply progressive, child-centric, and financially savvy compromise. In the harsh reality of family law, historical trends demonstrate that birdnesting is a catastrophic vulnerability for men. It entirely blurs the legal date of separation, keeping you completely financially entangled with a hostile counterparty. It requires flawless, impossible communication regarding household expenses, grocery bills, and property maintenance. Most dangerously, it creates a massive, ongoing physical intersection between two people engaged in adversarial litigation, exponentially increasing the statistical probability of a domestic disturbance call, an argument over missing documents, or allegations of stalking and privacy violations. When a couple cannot agree to sell, and birdnesting inevitably fails, the coastal courts hold another powerful tool known as a deferred sale of home order. In jurisdictions like California, this is historically referred to as a Duke order. If the court determines that the immediate sale of the family home would cause undue psychological or developmental harm to minor children, and the custodial parent cannot afford a buyout, a judge has the discretionary power to order that the house cannot be sold until the youngest child graduates from high school or reaches the age of 18. For a man facing this potential outcome, the results are draconian. Your physical capital is entirely legally trapped in the property for what could be a decade or more. You remain officially listed on the mortgage, meaning your debt-to-income ratio remains heavily saturated, fundamentally preventing you from qualifying for a mortgage to purchase your own separate property. You are functionally forced to act as an uncompensated landlord, deeply subsidizing the coastal standard of living for your ex-wife and children, while you are mathematically relegated to renting a small apartment indefinitely. The only viable way to bypass the deferred sale order, survive the taxation trap, and avoid the impossibility of a high-rate refinance is to utilize sophisticated asset offsetting. This requires treating the divorce exactly like a corporate restructuring. You must deploy forensic accountants to determine the precise, post-tax value of every single asset in your portfolio. A common historical strategy involves the man relinquishing his entire claim to highly liquid, pre-tax assets, such as his 401k, his vested stock options, or his separate brokerage accounts, transferring them entirely to the spouse in exchange for her equity in the physical house. However, this is an incredibly delicate maneuver that requires ruthless mathematical precision. Trading $1 of pre-tax retirement money for $1 of post-tax home equity is a fundamental imbalance that naive men agree to every day simply to maintain possession of a house. You must factor in the inherent deferred tax liabilities of retirement accounts and the illiquid nature of real estate to ensure you are not trading your actual financial future for a heavily mortgaged structure of wood and concrete. You have meticulously navigated the treacherous real estate negotiations. You have utilized advanced tax modeling, avoided the birdnesting trap, and structured a brilliant asset offset that allows you to preserve your capital and stabilize your living situation. You take a breath, assuming the most complex financial hurdles are finally behind you. But in a high-conflict coastal divorce, the preservation of capital is often just the opening skirmish. Opposing counsel realizes that they cannot break you financially on the spreadsheets, so they pivot their strategy to target the one vulnerability you cannot protect with a forensic accountant. They target your legacy. As the financial discovery closes, you suddenly receive a motion requesting an emergency, comprehensive child custody evaluation, accompanied by a staggering list of fabricated allegations regarding your fitness as a parent. What do you do when the objective mathematics of property division are replaced by the highly subjective, deeply biased, and psychologically brutal arena of a coastal custody battle, and your entire relationship with your children is placed in the hands of a single court-appointed therapist? When a coastal family court orders a comprehensive child custody evaluation, you are no longer participating in a standard legal dispute. You are being subjected to a rigorous, highly invasive forensic psychological audit. In jurisdictions like California, this is often referred to as a 730 evaluation, named after the specific evidence code, while in New York, it involves the appointment of a forensic evaluator by the Supreme Court. Regardless of the regional terminology, the mechanics are universally terrifying. The judge, recognizing that they lack the clinical expertise to determine the psychological best interests of a child in a high-conflict scenario, completely delegates that monumental responsibility to a single, privately retained, licensed mental health professional. Because family court judges are drowning in staggering 2026 caseloads, historical trends show that they will adopt the recommendations of the forensic evaluator's final report in the vast majority of cases. The evaluator's subjective opinion functionally becomes your legal reality. Imagine if you are a man named Jonathan, an orthopedic surgeon living and practicing in Manhattan in the year 2026. Jonathan routinely works 60 to 70-hour weeks, a demanding schedule required to maintain his surgical practice and afford a notoriously expensive Upper East Side lifestyle for his family. During the initial divorce filings, his estranged wife, seeking to maximize her child support leverage and secure permission to eventually relocate out of state, files a motion claiming Jonathan's grueling medical career makes him an erratic, exhausted, and emotionally absent father. She paints a picture of a man who is a physical danger to the children due to sleep deprivation, and claims he possesses a volatile temper when confronted about his workaholism. She demands sole legal and physical custody, formally requesting that Jonathan be relegated to supervised visitation every other weekend. The court immediately orders a full forensic custody evaluation to investigate these devastating allegations. Jonathan is suddenly ordered to pay a $35,000 retainer for a court-appointed psychologist to effectively place his entire personality, his history, and his relationship with his children under a microscope. The single greatest mistake men make during this process is fundamentally misunderstanding the role of the evaluator. Many men walk into the evaluator's office and treat the psychologist like a traditional therapist. They sit on the couch, let their guard down, and begin venting exhaustively about their ex-wife's narcissism, her financial irresponsibility, or her erratic behavior. This is a fatal strategic error. The evaluator is not there to heal your emotional wounds, and they are definitely not your advocate. They are a professional judge of character, specifically looking for signs of high-conflict personality disorders, rigidity, and an inability to foster a positive relationship between the child and the other parent. If Jonathan spends his 2-hour clinical interview aggressively attacking his wife's character, the evaluator will document him as vindictive, hostile, and actively engaging in parental alienation. You must treat every interaction with the custody evaluator exactly as you would a high-stakes corporate deposition. You must pivot away from emotional grievances and focus entirely on empirical, demonstrable evidence of your capacity to co-parent effectively. To survive this psychological gauntlet, you must understand the clinical tools being deployed against you. The evaluator will almost certainly require you to complete extensive psychometric testing, most commonly the Minnesota Multiphasic Personality Inventory, or the MMPI-3 in its current 2026 iteration. This is a grueling multi-hundred question psychological assessment designed to detect hidden pathologies like paranoia, psychopathy, and severe depression. More importantly, these modern assessments contain sophisticated validity scales, commonly known as lie scales. If Jonathan tries to outsmart the test by answering every question in a way that makes him look like a flawless, angelic parent who never experiences stress or anger, the validity scale will instantly flag his profile as faking good. The evaluator will conclude that Jonathan is deceptive, highly defensive, and lacks basic self-awareness, which is a catastrophic finding in a custody report. You must answer these assessments with a strategic, grounded honesty, acknowledging normal human flaws while demonstrating absolute stability and emotional regulation. Beyond the clinical testing, the evaluator will conduct home observations and interview collateral contacts. This is where the geographical reality of affluent coastal cities becomes a major vulnerability. In dual-income or high-net-worth households in places like San Francisco or Boston, a significant portion of childcare logistics is often outsourced to nannies, au pairs, or private tutors. The evaluator will actively interview these individuals, alongside pediatricians and private school teachers. If the historical reality of your household was that the mother and the nanny managed 100% of the medical appointments, parent-teacher conferences, and extracurricular scheduling while you exclusively generated income, the evaluator will meticulously document that you lack fundamental, hands-on caregiving skills. You cannot suddenly transform into a super dad the week the evaluation begins. Evaluators are highly trained to spot performative parenting. To secure a 50-50 custody arrangement, you must possess a verifiable, heavily documented history of actively participating in the granular details of your children's lives. You must produce the email threads with the math tutor, the sign-in sheets at the pediatrician's office, and the coaching schedules for weekend sports leagues. You must also master the concept of reflective functioning. When the evaluator asks Jonathan about his children, they are not just looking for a recitation of their favorite foods or hobbies. They are testing Jonathan's capacity to understand his children's internal emotional landscapes separate from his own. When asked how the divorce is impacting his son, if Jonathan replies that his son is fine because he just bought him a new gaming console, he fails the test. He is demonstrating a dangerous reliance on material compensation, often referred to in family law as Disneyland dad syndrome. A successful response requires Jonathan to acknowledge the profound grief and instability his son is experiencing, outline the specific therapeutic resources he has secured to help his son process that trauma, and demonstrate a willingness to shield the child from the adult conflict. The courts in 2026 are aggressively prioritizing parents who demonstrate high emotional intelligence and an absolute, unwavering commitment to co-parenting, even when the counterparty is highly combative. You endure the psychological testing. You successfully navigate the collateral interviews without a single negative report from the pediatricians or the school faculty. You maintain absolute stoicism in the face of fabricated allegations, and the evaluator officially submits a massive 70-page report to the court entirely rejecting your spouse's request for sole custody. The evaluator recommends a completely equal, 50-50 timeshare in joint legal custody, completely validating your fitness as a father. The judge reviews the document and issues a binding order solidifying your permanent parental rights. The emotional war over your children is finally definitively over. You take a massive sigh of relief, knowing your legacy is protected. Now it is time to conclude the financial division. Both legal teams schedule a mandatory settlement conference to finalize the final asset spreadsheets and officially dissolve the marital contract. You are exhausted, ready to sign the decree, accept your heavy financial losses, and begin rebuilding your life. But as the meeting begins, your forensic accountant stops the proceedings and slides a highly redacted financial ledger across the mahogany table. They have discovered a massive, deliberate irregularity hidden deep within the electronic discovery. Something terrifying has happened in the shadows of the marital estate during the 18 months of litigation. What happens when you discover that your spouse has been systematically draining the community estate through complex, decentralized digital networks? And how do you trace a financial ghost in the modern era of cryptocurrency and shell corporations? Tracing a financial ghost in the modern digital economy requires fundamentally discarding everything you thought you knew about traditional marital asset division. In previous decades, a spouse attempting to hide money during a divorce in a coastal city would typically funnel fiat currency into offshore bank accounts, purchase high-value physical commodities like gold or art, or perhaps establish a rudimentary shell corporation in Nevada or Delaware. These archaic methods were relatively easy for a competent legal team to uncover using standard subpoenas and basic forensic accounting. However, in the year 2026, the landscape of financial infidelity has violently evolved. High-net-worth divorces in tech hubs like Miami, Silicon Valley, and New York frequently involve complex decentralized finance protocols, self-hosted cold storage wallets, and layered digital transactions specifically designed to obscure the chain of custody. When your forensic accountant slides that redacted ledger across the table, they are not pointing to a simple missing wire transfer. They have discovered a sophisticated, calculated campaign of financial extraction. Imagine if you are a man named William, a successful commercial real estate developer living in Miami. Throughout the final 2 years of your deteriorating marriage, your wife quietly assumed total control of paying the quarterly estimated taxes and managing the secondary investment portfolios. You never questioned this arrangement because you were entirely consumed by the demands of a volatile coastal real estate market. Fast forward to the final stages of your divorce settlement. You believe you are dividing a liquid estate of roughly $4 million. However, your forensic accountant uncovers a disturbing historical trend. Over a period of 18 months, immediately preceding the legal date of separation, your spouse executed a series of seemingly innocuous incremental ACH transfers. These transfers were categorized in your joint banking software as miscellaneous consulting fees, digital software subscriptions, and routine wealth management retainers. In reality, these were fiat on-ramps. Your spouse was systematically purchasing stablecoins and transferring them directly into a decentralized, non-custodial hardware wallet that requires a physical device and a private seed phrase to access. Because decentralized ledgers operate outside the jurisdiction of traditional banking subpoenas, opposing counsel will routinely deny the existence of these funds, forcing you to prove a negative. This is where the sheer unyielding power of modern blockchain forensics comes into play. You cannot subpoena a decentralized network, but you can absolutely subpoena the centralized points of entry. Your financial experts will execute targeted discovery requests against major domestic cryptocurrency exchanges, demanding all know your customer data associated with your spouse's name, email addresses, phone numbers, and IP addresses. Even if she used a secondary device or a virtual private network, the forensic team will trace the original fiat transactions from your joint checking account directly to the specific exchange. Once that connection is established, the blockchain itself becomes her worst enemy. Because public blockchains act as immutable, permanent ledgers, your forensic team can trace the exact flow of every single token, identifying exactly which anonymous wallet address received the diverted marital funds. Discovering the hidden assets is only the first phase of the battle. Weaponizing that discovery is where coastal family law becomes incredibly punitive. In community property states like California, and through equitable distribution frameworks in states like New York, spouses owe each other the highest standard of financial transparency, legally known as a fiduciary duty. This duty mandates absolute good faith and fair dealing, specifically prohibiting one spouse from taking unfair advantage of the other. When you empirically prove to a family court judge that your spouse intentionally routed hundreds of thousands of dollars into an undisclosed digital wallet, you are not simply proving that the asset pool is larger than she claimed. You are proving malicious fraud. Historical case studies demonstrate that judges in highly regulated coastal jurisdictions have zero tolerance for deliberate financial obfuscation. Upon proving a severe breach of fiduciary duty, the court has the discretionary power to enact devastating statutory penalties against the offending spouse. Instead of simply dividing the newly discovered hidden crypto wallet 50-50, the judge can award 100% of the concealed asset entirely to you, while simultaneously ordering your spouse to pay the entirety of the forensic accounting and legal fees you incurred to uncover her fraud. However, cryptocurrency is not the only mechanism for modern financial deception. Another highly prevalent, incredibly dangerous tactic utilized in affluent coastal divorces is the strategic overpayment of federal and state taxes. This maneuver is devastatingly simple and frequently completely overlooked by men eager to finalize their divorce. In the year leading up to the separation, the controlling spouse will purposefully and massively overpay the estimated income taxes using joint marital funds. On paper, the marital bank accounts appear legitimately depleted, lowering the overall visible liquidity of the estate. Then, immediately after the divorce is finalized and the marital property is formally divided, the offending spouse files an amended individual tax return, claiming the massive overpayment and routing a six-figure tax refund directly into their newly established, separate checking account. To combat this, your forensic accountant must meticulously audit your historical tax liabilities against the actual estimated payments made during the final years of the marriage, demanding that any anticipated tax refunds be explicitly addressed, calculated, and equitably divided within the final legal decree. You must also rigorously audit the valuation of secondary business entities and professional practices. It is a common historical trend for a spouse who owns a small business or consulting firm to artificially deflate their revenue during the divorce proceedings. They will instruct their high-paying clients to delay settling massive invoices until after the divorce is officially finalized, or they will prepay a suspicious amount of business expenses to artificially crash their profit margins, thereby reducing the asset valuation and their respective spousal support obligations. Your team must utilize aggressive discovery tactics, subpoenaing the account's receivable ledgers, client contracts, and vendor communications to expose these shadow accounting practices. You must force the opposing side to recognize the true, unmanipulated value of the community estate, ensuring that you are not negotiating against a curated illusion of poverty. By deploying ruthless forensic accounting and leveraging the punitive power of fiduciary duty statutes, you successfully recover the stolen digital assets, neutralize the tax refund scheme, and finalize the financial division. The judge signs the final dissolution decree. The marital contract is officially severed. You have survived the grueling financial gauntlet, protected your retirement, and secured your hard-fought custody schedule. You sign a lease on a new residence, begin rebuilding your independent life, and finally experience the first genuine moment of peace you have felt in years. But in the high-stakes reality of family law, a final decree is rarely the end of the war. It is simply a transition into a new, heavily regulated phase of ongoing legal entanglement. Just as you settle into your new rhythm as a co-parent, you are served with a fresh, terrifying legal petition. Your ex-spouse, claiming the cost of living on the coast is too high, has just filed a formal motion requesting court permission to relocate 3,000 miles away to the Midwest, and she intends to take your children with her. How do you defend your parental legacy when the court is asked to legally authorize the physical destruction of your custody arrangement? And what specific legal standards will the judge use to decide if you are reduced to a father who only sees his children on summer vacations? The legal standard the judge will use to decide your fate in this terrifying scenario is centered entirely around a concept known as the best interest of the child, coupled heavily with the legal burden of proving detriment. In the highly specialized realm of family law, this is officially referred to as a move-away or relocation case. Across historical trends in family court litigation, attorneys universally consider relocation disputes to be the most difficult, emotionally devastating, and legally complex battles in the entire judicial system. Unlike dividing a retirement account or selling a physical house, you cannot split a child geographically. There is no mathematical compromise when one parent wants to live in New York and the other wants to move to Texas. It is a binary winner-take-all legal death match. The judge is forced to make a profound, life-altering binary decision that will inherently devastate one parent while rewarding the other. To understand why this is happening with terrifying frequency, you must look at the macroeconomics of the year 2026. The cost of living in United States coastal cities has completely decoupled from average historical salaries. A single parent receiving standard child support in a city like San Francisco, Seattle, or Boston often finds it mathematically impossible to afford a 3-bedroom home in a safe neighborhood with an adequate public school district. However, if that same parent takes their settlement and moves to the Midwest or the Sun Belt, they can instantly secure a drastically elevated standard of living. This massive economic disparity creates an overwhelming financial incentive for the custodial or joint custodial parent to attempt to legally remove the children from the high-cost coastal jurisdiction. Let us look at a case study based on potential outcomes in historical case law. Imagine if you are a man named Thomas, a senior structural engineer living in Los Angeles. Thomas fought a brutal 18-month legal battle to secure a strict 50-50 physical custody arrangement of his 2 young daughters. He restructured his entire corporate career, sacrificing promotions to accommodate a rigid schedule of school pickups, medical appointments, and extracurricular activities. 6 months after the final divorce decree is signed and the ink is barely dry, his ex-spouse files a formal move-away petition. Her stated intent is to permanently relocate the children to Columbus, Ohio. Her legal argument presented to the court is highly compelling on the surface. She argues that the Los Angeles rent she is currently paying is completely unsustainable. The specific public schools in her coastal district are statistically underperforming, and she has secured a lateral corporate job transfer in Ohio that offers a slightly lower salary, but a drastically improved overall cost of living. Furthermore, she emphasizes that her extended family resides in Ohio and can provide a massive network of free childcare and emotional support. Thomas is facing an absolute nightmare. If the family court judge grants this relocation petition, Thomas's 50-50 physical custody arrangement is instantly and permanently evaporated. He will be legally downgraded to a standard long-distance parenting plan. Historically, this means he will be reduced to seeing his daughters on alternating major holidays and perhaps a 4 to 6 week block during the summer recess. To prevent this complete erasure of his parental legacy, Thomas must engage in a highly specialized, incredibly expensive legal defense. He cannot simply stand before the judge and argue that he loves his daughters and will miss them terribly. The family court does not operate on parental sentiment. It operates strictly on statutory factors and empirical evidence. In coastal jurisdictions, courts historically rely on a specific set of criteria to evaluate a relocation request. The judge will heavily scrutinize the primary, underlying reason for the proposed move. Is it a legitimate, necessary career opportunity combined with a genuine desire for a better quality of life? Or is it a bad faith, punitive attempt to geographically alienate the non-moving parent? The court will carefully evaluate the distance of the relocation, the current age and developmental stages of the children's specific psychological ties to both parents, and the comparative educational, medical, and social resources available in both the current coastal location and the proposed destination. The most critical element of this entire battle is the burden of proof, which often shifts dynamically based on your existing custody order. Because Thomas already possesses joint physical custody, the court generally assumes that disrupting this established, highly successful co-parenting dynamic will cause an inherent, profound detriment to the children. Therefore, the heavy legal burden falls squarely on his ex-spouse to empirically prove that the overwhelming benefits of moving to Ohio fundamentally outweigh the severe psychological trauma of severing the children's daily, physical access to their father. How does Thomas successfully fight back against this narrative? He must systematically prove that Los Angeles, despite its immense geographical cost of living, remains the absolute optimal environment for his daughter's development. This requires assembling a new team of experts. Thomas must hire independent educational consultants to formally evaluate the proposed Columbus School District against the Los Angeles schools, specifically highlighting specialized advanced placement programs, cultural diversity metrics, or highly niche extracurriculars his daughters are already deeply embedded in. He must document his exhaustive, daily involvement in their lives, proving to the court that he is not a peripheral weekend figure, but a central, irreplaceable pillar of their psychological framework. Furthermore, Thomas can utilize a powerful strategic countermeasure by offering to modify the existing financial arrangement. He might legally agree to take on a significantly larger percentage of the children's direct educational and medical expenses in Los Angeles, effectively neutralizing his ex-spouse's primary argument regarding the unbearable cost of coastal living. It is vital to contrast this scenario with a different potential outcome. If Thomas had lost the initial custody battle and was only granted 20% visitation, in that scenario, historical trends overwhelmingly show that coastal courts are drastically more inclined to grant the relocation. If the father is already viewed by the system as a secondary, non-custodial parent, the court heavily prioritizes the primary custodial parent's fundamental right to travel and pursue a better economic reality. This terrifying dichotomy is exactly why the initial custody evaluation discussed in the previous section is so profoundly critical. It establishes the foundational legal baseline that dictates your standing in every single future conflict. Thomas spends another $90,000 in specialized litigation fees, hires a new slate of forensic psychologists, and endures another grueling multi-day trial. The judge, recognizing Thomas's profound, heavily documented bond with his daughters and his absolute willingness to further subsidize their coastal lifestyle to maintain stability, formally denies the relocation request. The children are legally ordered to remain in Los Angeles County. Thomas has successfully protected his family structure for the second time, achieving an incredible victory. But the financial and psychological toll of this victory is absolute. He has entirely depleted his life savings, liquidated his remaining, highly taxed stock options, and maxed out multiple credit lines simply to fund this necessary defense. He is functionally bankrupt, despite earning a massive coastal salary. As the reality of his depleted bank accounts sets in, opposing counsel realizes that Thomas is completely financially exhausted. They recognize that while they cannot beat him on the empirical merits of the custody case, they can absolutely destroy him through the sheer financial friction of the legal process itself. What do you do when your ex-spouse, emboldened by their own deep pockets, backed by aggressive legal financing, or simply driven by absolute vindictiveness, launches a relentless campaign of vexatious litigation, burying you in endless, frivolous motions designed not to win on legal merit, but simply to bankrupt you into total submission? How do you survive when the family court system itself is actively weaponized as an instrument of infinite financial attrition? Surviving the weaponization of the family court system requires a fundamental paradigm shift in how you view the legal process. You must understand that in the high-stakes environment of a coastal divorce, litigation is rarely about uncovering the objective truth or achieving a morally fair outcome. For highly aggressive opposing counsel, litigation is a business model, and the court system itself is a highly efficient machine designed to extract wealth from the primary earner. This strategy is known in the legal industry as vexatious litigation or financial attrition. The objective is not to defeat you on the empirical merits of the law, because the facts may actually be entirely on your side. The objective is to absolutely hemorrhage your financial reserves by drowning you in an endless, suffocating avalanche of frivolous motions, discovery requests, and emergency hearings until you simply run out of money and are forced to accept a highly unfavorable settlement just to stop the bleeding. Imagine if you are a man named Richard living in San Francisco in the year 2026. Richard is a senior partner at a venture capital firm. He has successfully navigated the property division and secured a highly contested custody agreement. He assumes the worst is behind him. However, his ex-spouse hires a boutique litigation firm notorious for scorched earth tactics. Within a span of 4 months, Richard is hit with a relentless barrage of post-judgment motions. First, they file a motion demanding a massive upward modification of spousal support, claiming a sudden unsubstantiated increase in their cost of living. Next, they file an emergency motion alleging Richard failed to properly disclose a minor, illiquid startup investment made 3 years prior, demanding a full reopening of the asset division. Then they serve his employer with a wildly broad subpoena, demanding access to years of proprietary firm communications to allegedly verify his bonus structure. Every single one of these filings is legally baseless and empirically weak, but the terrifying reality of the coastal legal system is that you do not have the option to simply ignore a baseless lawsuit. Every single time that opposing firm files a 50-page motion full of fabricated grievances, Richard is legally forced to defend himself. He must instruct his own high hourly rate attorney to read the motion, research the relevant case law, draft a comprehensive response, compile exhibits, and physically appear in front of a judge to argue the case. A completely frivolous motion that took opposing counsel 3 hours to draft using a boilerplate template might cost Richard $15,000 to successfully defeat. If the opposing side files one of these motions every single month, Richard is burning through a staggering amount of capital just to maintain the exact same legal position he already held. Historical trends demonstrate that this specific tactic is designed to induce a phenomenon known as legal abuse syndrome. It is a calculated form of psychological warfare. The goal is to induce such profound anxiety, sleep deprivation, and financial terror that Richard begins to underperform at his venture capital firm, putting his actual employment at risk. The opposing counsel wants Richard to dread opening his email inbox on a Friday afternoon, knowing that another massive legal bill or a new court date is waiting to destroy his weekend. To survive this infinite financial attrition, you must proactively build a fortress around your capital and aggressively pivot from a defensive posture to an offensive legal strategy. The most critical weapon in your arsenal against vexatious litigation is the strategic demand for legal sanctions. In highly regulated coastal jurisdictions like California, the Family Code specifically contains provisions designed to punish a party who actively frustrates the policy of the law to promote settlement and reduce the cost of litigation. You cannot simply complain to the judge that the other side is being mean or aggressive. You must meticulously document a clear, undeniable historical trend of bad faith litigation. You do this by aggressively making highly reasonable, mathematically sound settlement offers in writing. When Richard receives the frivolous motion regarding the startup investment, his attorney does not just blindly prepare for trial. His attorney sends a formal, legally binding communication to the opposing counsel, clearly outlining exactly why the motion is baseless, providing the specific documentation proving the asset was already disclosed, and offering a minor, face-saving concession to settle the issue immediately without court intervention. If the opposing counsel rejects that reasonable offer and forces a court hearing, Richard wins the hearing, and then his attorney immediately files a motion for sanctions. They present the judge with the written settlement offer and prove that the opposing side actively chose to waste the court's time and Richard's money. When a family court judge in a heavily backlogged coastal district sees a party actively refusing reasonable settlements just to drive up billable hours, the potential outcomes shift dramatically. The judge has the absolute discretionary power to order Richard's ex-spouse to completely reimburse him for the entire $15,000 he spent defending against the frivolous motion. However, there is a massive, terrifying geographical trap regarding attorney fees that frequently destroys men on the coasts, commonly referred to as the need and ability to pay doctrine. In states like New York and Massachusetts, the court operates under the premise that both parties must have equal access to legal representation to ensure a fair trial. If you are a high-earning executive making $800,000 a year, and your estranged spouse has not worked in a decade and reports zero income, the court will look at the massive disparity in your respective financial realities. To level the playing field, the judge can legally order you to pay for your ex-spouse's attorney. This means you are literally forced to write a massive check to fund the very legal team that is actively trying to destroy your life. You are paying for the sword that is cutting you. Defeating the need and ability to pay trap requires absolute financial precision. You cannot simply refuse to pay, as that will result in an immediate contempt of court charge. Instead, your legal team must aggressively audit the opposing counsel's billing statements line by line. Historical case studies show that aggressive litigation firms will routinely overbill, double charge for administrative tasks, or utilize senior partners for basic document review to artificially inflate their fee requests. Your attorney must file motions to strictly cap the fee awards, proving to the court that the opposing side is engaging in excessive, unnecessary litigation that goes far beyond the scope of a reasonable defense. Furthermore, you must aggressively utilize the vocational evaluation strategies discussed earlier to legally impute income to your spouse, proving to the court that they possess their own earning capacity and should be utilizing their own financial resources to fund their legal representation, rather than treating you as an infinite ATM. Men who survive this brutal phase of the coastal divorce process in 2026 are increasingly abandoning the traditional blank check retainer model of legal representation. They are pivoting toward unbundled legal services and flat fee litigation models. Instead of paying an attorney $900 an hour to slowly review thousands of pages of bank statements, they are hiring specialized, flat-fee forensic paralegals to conduct the raw data analysis, only bringing the senior litigator in for the actual court appearances and high-level strategic negotiations. They treat their legal defense exactly like a corporate procurement process, demanding absolute efficiency, transparent billing, and a ruthless focus on return on investment. You must learn to coldly calculate the mathematics of litigation. If it costs $20,000 in legal fees to fight over a $10,000 discrepancy in a brokerage account, you do not fight. You strategically concede the minor battles to starve the opposing counsel of billable hours, completely neutralizing their business model. You endure the barrage of motions. You successfully secure sanctions against the opposing counsel, stopping the vexatious litigation in its tracks. You cap the attorney fee awards, protecting your remaining capital. The opposing law firm, realizing that you are an impenetrable, highly educated target who will not simply bleed cash on demand, finally advises your ex-spouse to sign the global settlement agreement. The final documents are stamped by the court clerk. The ultimate, absolute legal finality you have been fighting for over the last 2 years is finally achieved. The war is over. But as you sit in your new, quiet apartment on a Tuesday evening, surrounded by unpacked boxes, the adrenaline that fueled you through the litigation abruptly vanishes. The legal machinery stops, leaving you entirely alone in the sudden, deafening silence of the aftermath. What do you do when the fight for your survival ends, and you are forced to look in the mirror and figure out exactly how to rebuild your identity, your career, and your entire existence from the ashes of a coastal divorce? The immediate aftermath of a finalized coastal divorce is a psychological landscape few men are truly prepared to navigate. For the past 2 to 3 years, your entire central nervous system has been locked in a state of hypervigilant fight or flight. Every time your phone buzzed, you braced for a catastrophic email from your attorney. Every bank transaction was scrutinized for potential weaponization by opposing counsel. Now the machine has stopped. The sudden absence of that manufactured crisis creates a profound, disorienting vacuum. Historical trends in post-divorce psychology reveal that men in high-pressure coastal environments frequently experience a severe delayed trauma response during this exact phase. You are no longer fighting for your financial life. You are simply living in the severely diminished reality of the outcome. You look around your rented, drastically downsized apartment in a secondary neighborhood, a far cry from the multi-million-dollar coastal home you spent a decade renovating, and the overwhelming weight of the reset finally crushes down on you. Imagine a man named Daniel, a senior systems architect living in Silicon Valley in the year 2026. Daniel survived the family court gauntlet, but the mathematical reality of his new life is entirely unforgiving. He earns a base salary of $280,000 a year, a figure that sounds wealthy in the Midwest, but operates like a strict working-class budget in the San Francisco Bay Area. After aggressive federal taxes, California state income taxes, his mandated massive monthly spousal support transfer, and his strict child support obligations, Daniel is left with roughly $6,000 a month in actual, liquid take-home pay. His modest, 2-bedroom rental in a lesser-known suburb consumes $4,000 of that instantly. Daniel is left with $2,000 a month to cover utilities, groceries, auto insurance, remaining legal debt servicing, and somehow begin the impossible task of rebuilding his completely decimated retirement portfolio at 48 years old. The potential outcomes for men in Daniel's exact demographic often involve severe burnout, because they are forced to work exponentially harder simply to tread water in a macroeconomic environment that is actively designed to drain their remaining capital. Rebuilding your financial architecture from absolute zero requires treating your personal life with the exact same ruthless, quantitative discipline you apply to your corporate career. You can no longer afford the ambient luxury of coastal living. You must engage in a process of extreme financial auditing. The men who successfully navigate this post-divorce desert and achieve secondary wealth do so by radically downgrading their ego. They do not attempt to maintain the illusion of their previous lifestyle. They drive heavily depreciated vehicles, they relentlessly meal prep instead of frequenting high-end coastal restaurants, and they temporarily eliminate all discretionary spending to rapidly aggressively pay down the high-interest debt incurred during the litigation phase. You must fundamentally accept that your first wealth-building cycle was legally confiscated, and your second wealth-building cycle must be built on a foundation of absolute minimalism and impenetrable defense. Parallel to this financial resurrection, you must completely re-engineer your career trajectory. During the years of active litigation, it is highly probable that your professional reputation suffered. You were distracted, exhausted, and likely missed critical networking opportunities or promotions because you were spending your afternoon sitting in a family court waiting room or on the phone with forensic accountants. Now you must pivot that intense, aggressive energy previously directed at your legal defense back into your professional market value. Historical case studies show that men who successfully recover often utilize this period to drastically pivot their careers, seeking high-equity startup roles, pursuing rigorous advanced certifications, or leveraging their newly acquired free time to build secondary income streams that are entirely separate from their primary W-2 earnings. You have been forcibly stripped of your previous identity, which means you now possess the dangerous, unencumbered freedom to build a completely new professional architecture that is strictly optimized for your new reality. Simultaneously, you must master the cold, mechanical logistics of the co-parenting reality. The court has handed you a legally binding physical custody schedule, but it does not provide an instruction manual on how to interact with a person who just spent 2 years attempting to destroy your character in public records. To protect your children from the radioactive fallout of the litigation, you must adopt a strictly business communications protocol. You do not engage in emotional debates, you do not litigate the past, and you do not respond to provocative text messages. You utilize court-approved parenting applications to communicate exclusively regarding the medical, educational, and logistical needs of your children. When you exchange the children at a neutral coastal location, like a public library parking lot or a local coffee shop, your demeanor must be entirely devoid of emotion, operating with the polite, distant professionalism you would reserve for a difficult corporate client. Your children will instinctively monitor these interactions, and your ability to project absolute stability and emotional neutrality will become the foundational bedrock of their psychological recovery. As the years progress and you successfully stabilize your finances, secure your career, and establish a healthy rhythmic co-parenting dynamic, a new and profoundly dangerous phase emerges. You will inevitably begin to re-enter the social and romantic marketplace. The statistical reality of the year 2026 is that men who survive a brutal divorce often find themselves highly sought after in the dating market once they rebuild their stability. They are vetted, experienced, and professionally successful. However, historical trends demonstrate a terrifying cyclical pattern. Many of these men, desperate for emotional connection and eager to rebuild a traditional family structure, will blindly walk right back into the exact same legal traps that destroyed them the first time. They will cohabitate without legal frameworks, they will commingle their newly rebuilt assets with a new partner, and they will sign marriage licenses in coastal states without a single shred of preemptive legal protection. They allow the intoxicating chemistry of a new relationship to completely override the brutal, expensive lessons they learned in the family court system. You must understand that the modern legal system does not reward romantic naivete. It aggressively penalizes it. If you have spent a decade bleeding out in a coastal family court, sacrificing your prime earning years to rebuild a modest portfolio and protect your legacy, the idea of exposing that fragile new empire to unmitigated risk is absolute madness. You must view any future relationship through the lens of strict asset protection. You must understand the specific legal mechanics of how cohabitation can inadvertently create common law marriage equivalents or palimony claims in certain progressive jurisdictions. You must comprehend how commingling a single dollar of your new, separate property into a joint checking account can instantly contaminate your entire portfolio, rendering it subject to division in a secondary dissolution. The survival skills you learn during your divorce are not temporary tools. They are the permanent, foundational rules of your new existence. But how do you actually implement these extreme protective measures without fundamentally destroying the trust and intimacy required for a healthy, functioning relationship? How do you sit down with a new partner you genuinely care about and demand that they sign a 50-page, ironclad prenuptial agreement drafted by a ruthless asset protection attorney? What are the specific, unbreachable legal mechanisms, from domestic asset protection trusts in Nevada to the strategic utilization of offshore corporate entities, that the ultra-wealthy use to completely remove their assets from the jurisdiction of coastal family courts altogether? And how can you deploy those exact same strategies to make yourself completely financially bulletproof before you ever even consider taking someone on a second date?